Earlier today at 9:33 a.m. Eastern Time, my office was formally informed that Melania Trump's attorneys rejected our proposed cooperation agreement. That agreement would have allowed her testimony to lessen Ivanka Trump's potential sentencing risk in the federal fraud prosecution. Melania declined. Just 17 minutes after that notice arrived, evidence began coming in. A Secret Service witness statement, text messages, a deleted social media post, all capturing the defendant's response after his lawyers told him Melania would not assist in keeping his daughter out of prison. Before brushing this off as mere family conflict, you need to understand what occurred from a legal standpoint. Federal prosecutors extended Melania a cooperation offer, testify about 3 specific financial transactions you personally witnessed, and we would recommend a reduced sentence for Ivanka. This is standard prosecutorial procedure. She refused. Ivanka Trump now faces 11 to 19 years in federal prison on bank fraud charges. With Melania's cooperative testimony, that exposure could have fallen to 6 to 10 years. That's the difference between her youngest child finishing elementary school while she's incarcerated versus finishing high school. And the defendant, based on evidence my office obtained this morning, lost control. I have documented proof of anger, threats, and what we legally describe as consciousness of guilt. Here's what I'm going to lay out. The timeline showing how both Melania and Ivanka became witnesses in my investigation, the 3 precise transactions where Melania had firsthand knowledge, the evidence of the defendant's reaction, the actual prison calculations for Ivanka, and the broader pattern because Ivanka is the 3rd Trump family member I've charged in related financial schemes. I'll continue covering this case as it progresses. Evidence, not spin. If you want to follow the facts, without tabloid distraction, subscribe. Let me begin with the timeline. April 15th, 2024. I authorized the first subpoena for Melania Trump's financial records connected to Trump Organization transactions. Her name appeared on bank paperwork as a signatory on accounts tied to fraudulent loan applications. Her signature was linked to 17 separate transactions between 2018 and 2022. By July 2024, my office had interviewed Melania twice under subpoena. She was not a target. She was a witness with direct knowledge of financial dealings between the defendant and Ivanka. Those proffer sessions revealed something critical. Melania was present at meetings where the defendant instructed Ivanka to falsify loan documents. She was physically there. She heard the discussions. She saw documents being altered. October 3rd, 2024. I charged Ivanka Trump with 3 counts of bank fraud, 2 counts of tax fraud, and 1 count of conspiracy. It was a strong case, but I knew Melania's testimony could make it airtight. December 9th, 2024. My office sent a formal proffer letter to Melania's attorneys. The terms were specific. Testify truthfully about 3 financial transactions you personally witnessed, and I will recommend a downward departure in Ivanka's sentencing. Her legal team requested 2 extensions. The January deadline passed. The February deadline passed as well. Her attorneys cited marital privilege concerns, which do not actually apply to business transactions. This morning, 9:33 a.m., a formal refusal. The letter from her legal team was concise. After careful consideration, Mrs. Trump declines the government's cooperation offer. She will not provide testimony in United States versus Ivanka Trump. No explanation, no counterproposal, just no. Spousal privilege protects private marital communications, conversations between husband and wife about personal matters. It does not protect business dealings conducted in the presence of others. Melania cannot be forced to testify about private conversations with the defendant, but meetings about Trump Organization financial transactions are business. Different rules apply. This refusal was not about legal privilege. It was a deliberate choice. Now let me show you precisely what testimony Melania could have given because the details matter. Transaction 1, May 17, 2019, Mar-a-Lago Executive Offices, a meeting attended by the defendant, Ivanka, Melania, and 2 Trump Organization accountants. The topic was a $47 million loan application to Deutsche Bank. I have emails confirming the meeting was scheduled. I have testimony from one accountant that the meeting occurred. What I don't have from Melania is her firsthand account of what the defendant allegedly told Ivanka about inflating asset valuations on the loan application. The accountant testified that the defendant instructed Ivanka to list property values using 2017 appraisals, which were significantly higher than 2019 market values. Melania was seated at that table. Her testimony would have supported the accountant's statement. Transaction 2, text message exchanges between Melania and Ivanka during August 2020. The subject was an IRS audit of Trump Organization tax returns. 15 text messages where Ivanka asks Melania for guidance on handling an asset disclosure issue. Melania's replies suggest knowledge of offshore accounts. One message states, and I'm quoting directly, "Use the Cyprus structure like we discussed with your father. They can't trace beneficial ownership." I wanted Melania to explain what Cyprus structure meant, what had been discussed with the defendant, and what she knew about concealing beneficial ownership. Transaction 3, first-hand knowledge of offshore accounts controlled by Ivanka. Bank records show Melania was listed as an authorized user on 2 accounts in Cyprus and 1 in the Cayman Islands. Total deposits across those accounts from 2018 to 2022 amounted to $18.4 million. Melania's testimony could have clarified the source of those funds, the purpose of the accounts, and Ivanka's control over them. Here's what corroborating testimony means in plain terms. I already have documentary evidence, emails, bank records, text messages. I already have testimony from the accountants. But when a family member who was present confirms what the documents show, that's corroboration. It removes reasonable doubt. I prosecuted Paul Manafort for financial crimes. His daughter's text messages became evidence. Similar family dynamics. Business transactions do not receive family privilege protection. Now let me show you the evidence of how the defendant reacted when he learned of this refusal. This morning at 10:15 a.m., a Secret Service agent assigned to the defendant's protective detail submitted a voluntary witness statement to my office. The statement describes a phone call the agent overheard between the defendant and his lead attorney around 9:52 a.m. The defendant was inside a residential area at Mar-a-Lago when he received the call. The agent, positioned about 12 feet away providing standard protection, heard the defendant shout, and I quote from the statement, "Melania is betraying this family. She's siding with Smith against her own daughter." The call lasted roughly 4 minutes. The agent noted escalating volume and profanity. When the call ended, the defendant allegedly hurled his phone against the wall, cracking the screen. That's evidence item 1, a sworn statement from a federal law enforcement officer. Evidence item 2, text messages between the defendant and his son, Eric Trump. Timestamped 11:03 a.m. this morning. The defendant wrote, "Make your mother understand what loyalty means to this family. Ivanka is facing prison because of her silence." Eric replied, "I'll talk to her." The defendant followed up, "Talk won't fix this. She needs to know there are consequences. I've prosecuted organized crime cases where family pressure became evidence of obstruction." This sequence, immediate rage followed by attempts to pressure other family members to influence a witness, is what we call consciousness of guilt. Evidence item 3, a Truth Social post published by the defendant at 11:27 a.m. and deleted at 11:44 a.m. It remained live for 17 minutes. Screenshots were captured and preserved. The post stated, "Disloyal wives who put prosecutors before family will learn what real consequences mean. Some people value their own skin over their children." Sad deleted 17 minutes later. Too late. I have the evidence. In court, this is called consciousness of guilt. Outside court, it means this. When someone responds with anger and threats instead of indifference, that behavior suggests awareness of wrongdoing. If Melania's testimony was irrelevant or untrue, why the outburst? Why pressure Eric? Why post the threat? I've built cases against mob bosses who turned on cooperating relatives. I recognize this pattern. Tell me in the comments, based on this reaction evidence, do you think it demonstrates consciousness of guilt, or is it simply family frustration? I'm interested in what you think. Now let me explain the real prison exposure Ivanka faces and why Melania's refusal is so consequential. 3 counts of bank fraud. Federal law allows up to 30 years per count, but federal judges rely on sentencing guidelines, a formula based on offense severity, criminal history, and acceptance of responsibility. For bank fraud involving loans over $10 million with sophisticated concealment, the guideline range is 8 to 12 years per count. Ivanka has 3 counts, but sentences usually run concurrently for related conduct. So the practical range for bank fraud is 8 to 12 years, 2 counts of tax fraud. The guideline range at this amount is 2 to 4 years per count. With concurrent sentencing, the practical range is 2 to 4 years, 1 count of conspiracy to commit fraud. The guideline range is 1 to 3 years. Judges stack these ranges when conduct is related but legally distinct. Bank fraud plus tax fraud plus conspiracy. The total exposure is 11 to 19 years. That's the baseline without cooperation credit. Here's where Melania's testimony would have mattered. Under federal guidelines, when a defendant's family member provides substantial assistance, judges can grant a downward departure. Typically, that's a 20 to 40% reduction. Her cooperation could have lowered Ivanka's exposure to roughly 6 to 10 years. Without it, my sentencing memo will recommend the high end of the range, 16 to 19 years, because there's no acceptance, no cooperation, and no mitigation. With cooperation, I could have recommended the low end, 6 to 8 years. Judges follow these recommendations about 85% of the time. There is no parole in the federal system. Ivanka would serve 85% of any sentence imposed. 16 years means serving at least 13.6 years. Now let me step back and show you the broader pattern. She is the 3rd Trump family member I've charged in Trump Organization cases, and it reveals how criminal enterprises function. Ivanka Trump is the 3rd member of this family I've charged for crimes arising from Trump Organization financial conduct. When prosecutors charge multiple relatives in connected schemes, it isn't vindictiveness. It's following evidence of coordinated criminal activity. The defendant himself was charged with 34 counts of business fraud and obstruction of justice for falsifying records to conceal hush money payments. Same organizational structure. Donald Trump Jr. charged with 2 counts of tax evasion and 1 count related to concealing foreign income through shell companies. Same methodology, offshore accounts, hidden ownership, false IRS statements. Now Ivanka, 3 counts of bank fraud, 2 of tax fraud, 1 of conspiracy. Different banks, different tax years, same pattern. All 3 cases involve falsified financial documents, offshore accounts to hide ownership, use of Trump Organization infrastructure, and coordinated family participation. In court, this is known as a continuing criminal enterprise. Outside court, it means a family-run business used to commit repeated financial crimes as an organization, not isolated acts. I prosecuted the Gotti family for RICO violations in the 1990s. Different crimes, same structure, father, sons, criminal enterprise disguised as legitimate business. I recognize this pattern. This investigation has taken years. We traced transactions through 17 countries, interviewed 134 witnesses, reviewed 4.7 million documents. Here's why Melania's refusal matters so much. She is the only family member with firsthand knowledge across all 3 cases. She witnessed meetings involving the defendant, had access to information about Don Jr.'s offshore accounts, and observed transactions central to Ivanka's charges. Her testimony could have tied the entire pattern together, showing coordination, proving this wasn't 3 separate cases but a family enterprise built on systematic fraud. She chose not to testify. Now here's what happens next. The trial date is set. Her decision is final. The clock is moving faster. Trial begins June 9th, 2026. That's 124 days from today. No more delays. Jury selection starts that day. March 15th, final motions due. April 7th, evidentiary hearings. May 1st, witness list finalized. June 2nd, jury questionnaires sent. June 9th, jury selection begins. Opening statements. June 12th. I'll present the prosecution case for roughly 2 weeks. June 12th through June 26th. Documents, witnesses, experts, the accountant from May 2019. Everything except Melania. The defense begins June 30th. Closing arguments around July 14th. Deliberations follow. Melania's refusal means I rely solely on documents and other witnesses. That evidence is overwhelming. Bank records showing inflated values, emails documenting instructions, text messages exposing concealment, testimony from cooperating accountants. I've prosecuted bank fraud for 30 years. Juries understand documents. Paper doesn't lie. Wire transfers of $47 million based on false valuations speak for themselves. The system works when evidence leads. Grand juries indicted, judges set trial dates. Now we watch it unfold. No one is above the law, not the defendant, not his sons, not his daughter. That's not a slogan. It's the principle I've applied in every case. Trial begins in 124 days. I'll be here to guide you through every development. Subscribe to follow the case and tell me in the comments, is documentary evidence alone enough for conviction without Melania's testimony? I read them all. We just covered Ivanka's prison exposure, but her trial is nothing compared to what happened to her father this morning. The judge read his sentence today.